It is 10:17. I'm Jeff Hullinger. Tonight, radioactive fallout after the Senate triggered the nuclear option this week, dramatically changing the rules of approving judicial nominees. They voted to lower the number of votes needed to break a filibuster from 60 to 51, a simple majority. Jonathan Nash, a political science professor at Emory, is here to put all of this into perspective. Jonathan, thanks for being here on a Friday night.
Thank you.
We really appreciate it. The president said this is necessary because of a pattern of obstruction in Congress. I want to play a clip of this interview, and then we'll get your reaction, okay?
Sure.
The vote, I think, is an indication that a majority of senators believe, as I believe, that enough is enough. The American people's business is far too important to keep falling prey day after day to Washington politics.
Jonathan, there are a lot of people that may not follow politics very closely. They want to understand the meaning of this and how it is relative to running the country.
Well, the filibuster empowers basically 60 senators. It requires 60 senators to break the filibuster in order to allow things to go forward. So by reducing the number of senators that can approve things down to 51, you're basically requiring, as you said, a simple majority, which makes things easier to go through the Senate.
Filibusters have been a part of Congress, of the Senate, forever and ever. It is an American tradition. Why throw it out in 2013, 2014 when it has been a part of how we do business?
Well, for one thing, it is not entirely thrown out. It is still applicable to legislation, which is pretty important, and in fact, even in the judicial context, to Supreme Court nominees. So the real question is, why throw it out specifically for lower court nominees? And the argument given is that an argument that has been given is that the lower courts have an overload, and without judges being confirmed, they're unable to fulfill their business. Of course, the political argument is that simply the president isn't able to get the people that he wants in office, and that could be true for presidents of either party.
I really feel like this really illustrates the old issue of the judicial and Congress make for strange bedfellows. It is sort of an awkward arrangement. It is a necessary arrangement, but that doesn't make it any easier.
It's a tough question generally because it isn't clear what the best way to appoint judges is. Many states, Georgia, will have elections, and a lot of people criticize that as a poor way to select judges. But as you were pointing out, even this nomination process also brings in politics. So you may be well facing a problem that it's very difficult to solve. You're definitely right. It isn't clear the right way out of this, and this may not be the best answer even for the Democrats who today are endorsing it. Remember that President Obama, just a few years ago, when he was in the Senate, opposed exactly this proposal.
We're running out of time here, but what sort of impact do you think that it has on Georgia? How do you see it?
Well, it's, I guess, a little different on lower federal courts in the state of Georgia, both the Court of Appeals and district courts. The local state senators actually have more authority to hold nominations and even to recommend people to be nominated to the president. So it's the largest impact is going to be felt on the District of Columbia Circuit, which is a court in Washington, but it hears a lot of administrative issues. So a lot of the president's agenda will come before that court. The court here in Atlanta, probably less of an effect, but at the same time, it still does give the president, assuming he can make a nomination, the power to get folks through the Senate with fewer votes, and therefore gives him more freedom to select who he wants to be on the court.
Jonathan Nash from Emory University, your first time on television. You knocked it out of the ballpark. Thanks.
Thank you very much, Jeff.
Yes, very nice job, gentlemen. All right, folks, we got a little bit of